Hello everyone, welcome to the channel Legal Ease. Today we are going to discuss the definition of decree. Decree is a very important concept under CPC and it has lot of essentials and lot of things that are needed to be understood while defining or while understanding that what decree exactly mean. Under CPC, we usually use the terms judgments, decree, orders interchangeably. And we do not understand what is the difference in these terms and why there is a difference in these terms. Why is it important to know the difference between these terms? So, first of all, why it is important to understand the meaning of these three terms is because the application of these three terms in CPC is different whenever you are going to a court and the decision of the court that is coming is a decree, then the consequence of going to an appeal execution is different in comparison to if the decision is an order. So that is why you need to understand how judgment is basically defined, or how you will determine whether a particular thing is a judgment or not, and from there how will you determine whether a decision is a decree from the judgment or an order. So let's first start with understanding the meaning of decree, because if you understand the meaning of decree, it will be easier for you to understand the other terms, that is the order and the judgment. So under CPC, decree is defined in section 2, subsection 2 of CPC. I'll share the slide so that it will be easier for you to look at it and then understand these terms. Okay, so decree as defined under CPC is this, and this is the whole definition of decree. It is, as I have mentioned, divided into three parts. The first part that is here, it defines decree. The other part, this particular second paragraph, it talks about the deemed decrees and the terms that are not a decree. And in the third part, it is talking about what is um, what is a preliminary decree, and what is a final decree, and what is a partly preliminary and partly final decree. When we will be moving or discussing about the decrees, after that I'll make a separate video on the different types of decrees like deemed decrees and preliminary, final, and partly preliminary and partly final decrees. First, let us focus only on the term that is the decree, so that we can understand the different points, different terms that are mentioned or defined under used to define it. So decree is means, or it is said that it means the formal expression of an adjudication, which so far as regards to the code expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and maybe the preliminary or final. So like I said, preliminary and final we'll discuss later. But for the time being, we need to understand the meaning of these terms. What is the meaning of formal expression, with meaning of adjudication, suit, matters in controversy, conclusive determination, and rights of the parties. So these are the basic essentials of a decree. Let us understand the meaning of each and every one. First of all, adjudication and a suit. Adjudication basically means the judicial determination of a case, or in the case of a decree, judicial determination of a suit. Judicial determination का meaning क्या होता है? Judicial determination means that the judiciary has applied its mind. Applied its mind again means that the judiciary has taken evidences into consideration from both the parties, and after taking evidence into consideration, the judiciary has given a decision. That means the judiciary has taken evidences from the plaintiff as well as from the defendant, and after taking evidences from both plaintiff and defendant into consideration, they have decided whether the decision should be given in favor of the plaintiff or in favor of the defendant. So this whole process is called as adjudication. If we talk about suit, suit means any proceeding that has been initiated with the presentation of plaint. This is also mentioned under section 26 of CPC, You can refer to that section which talk about the institution of the suit, and it says any suit, any proceeding which is instituted with the presentation of the plaint is counted as the suit. Along with that, they have added the concept of affidavit that is needed to be attached. But again, it is a procedural law. Generally, the procedural law does not uh, interpreted very uh, uh, strictly. It has a liberal interpretation, and that is why if you present a plaint in the court, it is considered that a suit has been instituted. So with the presentation of the plaint, a suit is instituted, and if in a suit the court is taking into consideration the evidences presented by both the parties, plaintiff and the defendant, and then giving a decision, then it is considered as adjudication in a suit. So these are the first two requirements that should be present in any decree. Coming to the next topic or next point, essential, that is the rights of the parties. The rights of the parties mean that it should be substantive rights of the parties. Now, when we talk about substantive rights of the parties, then what do we mean by substantive right? It means that the rights that are mentioned under the substantive law or that form the part of the substantive law of the parties, that are not mere procedural rights. That means not just the rights that are given under the procedure that do not form the part of the substance that is providing them with a remedy. Procedural is basically what is followed in a procedure, and those are the procedural rights. For example, right to get an adjournment is a procedural right. Right to file a suit as an indigent person is a procedural right. Right to get an injunction or to stay over a proceeding is a procedural right. So there are a lot of rights that are procedural in nature and are useful only for determining the procedure or getting fulfillment of the procedure of a particular suit or a proceeding. So that is a procedural right. While if any particular right is related to your substance determining your remedy in that particular suit, which is given rise to a cause of action, as we have already understood, those are the substantive rights. Whenever there is substantive right, then the decision over those rights is considered as the decree. And if it is not a substantive right or just or merely a procedural right, then the determination of those rights is not considered as a decree. The next point is the matters in controversy. Now, matters in controversy mean that it should be related to the things that are mentioned in the pleadings by the party. Pleadings, again, we will deal with the detail in the upcoming videos. It is mentioned under Order 6, the pleadings. And pleading basically consists of plaint and written statement. So what is the meaning of a plaint? What is the meaning of a written statement? Both of them constitute together as pleadings. All of these things will be discussed when we will be going in Order 6, Order 7 and Order 8 of CPC. But for now, the pleadings are basically the arguments based or made by both the plaintiff and the defendant. So everything that is mentioned in those pleadings that can be changed by way of amendments as well are considered as the matters in controversy. So if anything has been said casually or orally by the parties without going into or without having the intention of adding it into the pleadings of the parties, then that thing or that matter is not considered as matter in controversy. Usually matters in controversy are those matters that give rise to a cause of action. So like I have already told you, कि cause of action जब भी arise होता है, you prove your right. You prove the violation of your legal right, and then that will show your cause of action. And then you give evidences to prove or disprove that cause of action that will ultimately decide whether you should get the relief from the court or not. Now, when we talk about the matters in controversy, they basically are the determination of those cause of action, whether there is a legal right and the violation of those rights. That is the matter that is in controversy. One party is saying that there is no legal right, that becomes the controversial matter, whether there was a legal right or not. Or if the determination of the legal right is not in question, but the violation is in question, then the matter in controversy becomes the violation and the evidence is related to it. So that is what constitute the matters in controversy. Please go through the video of matter cause of action to understand it in detail. What do I mean by the matters in controversy in reference to the cause of action? Then the next is conclusive determination. Conclusive determination means that the rights should be determined conclusively by the court. That means there is nothing remaining or nothing left to be determined further by the court. The court has determined what is the remedy or what is the relief to be given by the party after judicially determining the contentions of both the parties. That is a conclusive determination, and formal expression means that Order 20 of CPC talk about certain essentials that are needed to be present in a decree. After those essentials are there, like there is a date, there is the place that should be mentioned, the name of the parties, the sign of the judges, or the seal of the court. So there are certain essential things that are needed to be present in the document that you are calling as a decree. If those things are there, it is the formal expression or formally expressed decree, and that together everything will call as a decree, and you will call that the decision is a decree, otherwise it will be an order. So for example, there is a very brief example in a dispute between A and B related to breach of contract, wherein A is claiming that we entered into a contract, both A and B, we entered into a contract for supply of cotton, 100 kg of cotton by B, for which A will be giving him rupees of, let's suppose, 10,000. Okay. Now, when A has filed this case that B has breached a contract, here he is saying that I have already paid 5,000 rupees to B in advance for the delivery of 100 kilogram of cotton. But B has not promised his fulfill his part of the promise, and he has not delivered me the cotton, and therefore I have suffered a loss of 5,000 rupees, as well as I already decided and appointed some workers to convert those cotton or use that cotton into making of clothes. And now I had already made investment in buying the machineries for that, and paying the workers for that. So ultimately, I have suffered a loss total. He has said that I should get damages of 30,000 rupees from B for the breach of contract and the expenditure that I have made in furtherance of that breach of contract. अभी यहाँ पे A will prove the cause of action has arisen because he had a legal right which arose through the existence of a contract, and therefore with this legal right violation was done because there was a breach of contract. Now what will B show? B will either show that there was no contract as such. If there was a contract, there was no violation on his part. He can say that there was no payment of 5,000 rupees, or B, A has already denied the delivery of 100 kg of cotton, or whatever the reason is. So यहाँ पे matter in controversy is whether there was a contract, whether there was a violation, in whose part the violation was there, and after the decision, the court will decide whether relief should be given to A or no relief should be given to any of the parties. So these are the things that will be determined. For that, so यहाँ पे rights क्या हो गए in controversy? Breach of contract, right to get damages. These are the substantive right mentioned under the Indian contracts. Indian Contract Act. The next is matters in controversy. We have already explained what are the matters in the controversy. Now, when the court, so here A has filed a plaint for that, so existence of a suit is also proved. What you have to do, see whether there was an adjudication. So if the court is collecting evidences from both A and B to see whether there was a contract, whether there was a violation, that means the court is also entering or doing the adjudication. When the court is also doing the adjudication, and if the court gives a decision on the basis of the evidences collected, and then the court conclusively determined whether there was a breach. If there was a breach, how much damages should be paid, who will get the damages. Let's suppose the court has said that there was a breach on part of B, and therefore A should get the damages of not 30,000 but only 20,000 rupees from B. Then it is the ultimate conclusive determination of that particular case. So this decision that we should give 20,000 rupees to A at within a period of 1 month at let's suppose 6% rate of interest, whatever the decision of the court is, that will be considered as a decree because all the essentials have been fulfilled. Here, obviously, it is necessary to see that the expression of the judgment or the decree should be formal as mentioned under order. So this is altogether is the meaning of decree, and this is how you will determine whether the decision is a decree or not. One important case and a landmark case in this regard is Deep Chand versus Land Acquisition Officer. In this case, the court talked about the adjudication and said that for considering a particular thing as an adjudication, there should be judicial determination of the dispute between the parties. If there is no judicial determination, it will not be considered as a decree. So, for example, any appeal dismissed in default, order dismissing suit for non-appearance of the parties, they do not amount to judicial determination of the matters in controversy because since it is default, that means the court has not gone into the details of the evidences. For non-appearance, again, the court is dismissing the case because the plaintiff was not appearing or was not present in the court, so the court did not get into the merits of the case. So in all these cases, it will not be a decree, and therefore the decision, again, since it is not a decree, will not be appealable unless it is an appealable order. So this is it about the decree. I hope I was able to make it clear for you. If there is any doubt, please mention it in the comment section so that in the next video, I will take up those doubts and I'll clear those doubts. If you, the name of the case, I'll mention in the description as well. If you want notes, if you want anything in detail, if you want any specific topic for me to explain to you, please let me know. I'll explain it in the next videos. For now, the next video, I'll be taking about the different kinds of decrees. Like I've told you, deemed decrees, preliminary decree, final decree. What are the meaning of these decrees? What are the essentials of these decrees? So everything will be discussed in those videos. So that's it for today. Thank you. And please subscribe to the channel Legalese and like, share as much as possible if you like the videos. It will give me, it will promote me to make more such videos, and if there is any improvement, and feel free to comment on it to tell me how I should go about it. Thank you.